This Honorable Court of Appeals of Tennessee is now in session.
Before we call the case, it's a reminder that we don't anticipate any technology-related problems, but if we should have any, we'll all just take a deep breath and pause and see if we can't get it resolved and then move forward. Call the case, please, Mr. Governor.
Michael Thomson versus Genesis Diamonds, LLC.
We'll hear from the appellant.
Thank you, Your Honor. My name's Eddie Schmidt. I represent Michael Thomson, the appellant in this case. And I'd like the court to bear in mind that I was not Mr. Thompson's original lawyer. I got involved in this case on the eve of the attorney fee hearing. The first time I had noticed that there were two filings in this case is when I got the motion to dismiss in the Court of Appeal. And I immediately called Mr. Thompson and said, what the heck is going on? He didn't know what was going on. I called his previous lawyer who kind of explained to me the circumstances of what happened. And with the court's indulgence, I'd like to kind of walk through the kind of confusing nature of what happened here. If you can look at this what I'm going to call a demonstrative aid, okay? The first lawsuit was filed in GS, that stands for General Sessions. And it was Michael Thomson versus Genesis Diamonds. And the parties agreed to transfer to circuit court, and it was assigned number 512. Now, for reasons that are still unclear to me, after the parties agreed to transfer the General Sessions case to circuit, Mr. Thompson's lawyer filed a complaint in circuit court, which was given number 598. Now, in response to Mr. Thompson's complaint 598, Genesis Diamonds filed a motion to dismiss against 598. Now, during the hearing before Judge Bird, these two files came before her attention. She said, what the heck's going on? And as I explained in the statement of facts, Mr. Thompson's lawyer said he really didn't understand what to do when the transfer is there. So that's why he filed a new complaint. And Judge Bird said, well, you need to amend your complaint. Mr. Thompson's lawyer amended 598. And I can tell you that because the first 14 paragraphs of the amended complaint are identical, verbatim, of the original 598. In the brief, I said it's 18, but it's actually 14. In response to the amended complaint, Genesis Diamonds files a motion to dismiss the amended complaint, 598. And that was the motion that was granted, in which two additional causes of actions were pled terribly, and they were dismissed, for which Genesis Diamonds seeks attorney's fees. Now, all of Genesis Diamonds' arguments here, and I put this in the brief, is premised on the fact that Genesis Diamonds assumes that there are two judgments. There's only one judgment because there was only one motion to dismiss. If there are not two judgments, then there's no subject matter jurisdiction issue and there's no res judicata issue. And I asked the court to ask Genesis Diamonds counsel point blank, do you find that do you submit, do you argue, do you suggest, do you insinuate that there are two judgments? There was only one judgment here. And that is the judgment from which he was being appealed, Your Honors. Nowhere in Genesis Diamonds' very lengthy, wordy brief is any argument or in suggestion or the words surprise or prejudice appear. And I think that's important in this case, Your Honors.
Let me count one thing. I mean, the trial court also ordered the two cases consolidated, right?
Yes, sir.
Okay, go ahead.
So in the waste management versus Metro case, and also in the NHC fire litigation case, in both of those cases, the notice of appeal was being contested as to whether it was adequate. The appellee argued that the appellant could not argue the merit of earlier trial court orders because only the final judgment was cited in the notice of appeal. And in both of those opinions, the Court of Appeal found that the notice was adequate because the appellee had no surprise, was not prejudiced by this notice of appeal. And I think that's the dispositive factor in this case, Your Honor. Genesis Diamonds cannot be surprised, nor is it as prejudiced in any way that what is being appealed here is the May 10, 2021 attorney fee order. Now, whether it's 2 orders or 3 orders or 1 order, that's what's on the notice of appeal, Your Honor. And I think that the lack of surprise and lack of prejudice is dispositive on this issue. And I ask that the motion to dismiss be denied. On this issue, I don't want to leave this issue unless the court has any questions, and I'm willing and able to answer any questions on this issue.
The amended complaint, did it have both docket numbers on the amended complaint?
Yes.
All right. Okay. In the order of dismissal, did it have both docket numbers on it?
Yes.
All right, go ahead.
And by the way, Your Honor, I'm glad you asked that question, because after the amended complaint was filed, every pleading filed by Genesis Diamonds had 598 followed by 512 in parentheses. Okay, now I'm not sure about Your Honor's experience, but in my experience, I don't pay a whole heck of a lot of attention to these numbers. I guess I should as a result of this bizarre incident. But the fact is, in the notice of appeal, there is no question, no surprise with regard to what's being appealed, and that is the May 10, 2021 attorney fee award. And there's only 2 parties, and there's only 2 parties ever in this case, and that is Mr. Thomson and Genesis Diamonds. Does the court have any other questions on this issue?
I hear none.
Okay. Now, with regard to the attorney fee award, I humbly submit that I believe Judge Collins abused discretion in the award for 2 reasons. Number 1, the award is not supported by the evidence of the record in this case. And secondly, it's contrary to the law. This was this amended complaint in 598 was very poorly done, in response to which Genesis Diamonds filed a motion to dismiss the 598. There were 5 grounds raised in that motion to dismiss. 2 were granted, and the 2 were granted dismissed for lack of cause of action. The second and third claims that Mr. Thomson alleged in the amended complaint. As I point out in my brief, the time that the Genesis Diamonds counsel spent for the dismissal of those 2 claims is not delineated. Nowhere is there any explanation of exactly what was done and what time was spent, what resources were used in dismissing those 2 claims. And under the statute 2012-119, reasonable and necessary attorney's fees are only awarded for the time and effort that it took in disposing those claims. And I submit that the record doesn't submit a $10,000 attorney fee award. Not only that in response to Genesis Diamond's motion to dismiss, Mr. Thompson's previous lawyer, not me, but his previous lawyer, didn't contest it. He made no argument. He essentially waived it. So there was really no contested claim there. Finally, Your Honor, the trial court made no mention in his oral arguments, in his oral reasons, nor in the final judgment that was rendered by Genesis Diamond's counsel as to the factors that he considered in awarding the attorney's fees under Rule 1.5A of the Rules of Professional Conduct. And as a result,
excuse me for interrupting. As I understand, there is not a transcript or statement of the evidence on this appeal in the record. Is that correct?
That's correct.
Does that have any bearing with regard to the amount of the attorney's fees or the reasonableness?
No, sir. There was no testimony presented in the hearing. The hearing was a Zoom hearing just like this. There was no testimony. The entire evidence was comprised of Genesis Diamond's counsel's affidavit. That was it. I mean, I guess by virtue, I had a right to cross-examine Mr. Horowitz, but that didn't happen. So I don't think the lack of a transcript really matters with regard to this. I think the judgment of the attorney's fees adequately represented the court's oral reasons, and there was no mention whatsoever of any of the factors comprised of 1.5A of the Rules of Professional Conduct. As a result, Your Honors, I humbly submit that the attorney fee award of $10,000 was grossly excessive and abuse of the trial court's discretion. I ask that the court remand this to the trial court for further proceedings. Now, with regard to this
counsel, let me ask you on something you said there. And I understand we don't have a transcript or no proof or anything done on that, but you just told us that basically your clients, then counsel, didn't really contest it. Is that correct?
No, sir. Mr. Thompson's previous counsel did not contest the motion to dismiss.
Motion to dismiss. Okay.
Yes.
All right. I misunderstood.
Okay.
My fault.
The 12.026 motion, that wasn't contested.
All right. I misunderstood.
The attorney's fee motion was contested. And that was me. That's when I got involved.
Okay. The $10,000, that's the cap under the statute, correct?
Yes.
How much of attorney fees were they requesting?
I think the maximum.
Well, how much attorney fee? I'm sure they requested the maximum of $10,000, but did they show attorney fees of more than $10,000?
Well, that was one of the problems, Your Honor, because in the affidavit of counsel, he delineates all these hours that were spent. Nothing was.
Counsel, I understand your argument. I'm just saying, what was the total amount of attorney fees listed on that affidavit?
I can't remember, but it was in excess of $10,000.
All right.
The argument of Genesis Diamonds is that it spent an inordinate amount of time on this case, and it was far in excess of the $10,000 limit. That was the argument.
The affidavit is part of the record.
Yes, sir.
Okay. Thank you.
And my time has expired. I reserve some minutes for rebuttal.
Thank you, counsel. Yes, you have your time for rebuttal. We'll hear from the appellee.
Morning, Your Honors.
Morning.
Daniel Horowitz of the Nashville Bar on behalf of the appellee Genesis Diamonds. Your Honors, despite what you have just heard, the circuit court's order on attorney's fees must be affirmed for three straightforward reasons. First, Mr. Thompson has neglected to appeal a final order in a consolidated case that is now preclusive of this appeal. Second, the reasonableness of a fee award is a factual determination. Whereas here, an appellant fails to file a transcript or statement of the evidence, though, this court conclusively presumes that the findings of fact made by the trial court are supported by the evidence and are correct.
What evidence? What evidence was presented other than the counsel's affidavit?
Well, Your Honor, there was such evidence. It was discussed at length. The reason I can't point you to the record is because appellant didn't file a transcript of it, didn't file a statement of it.
You're saying there was witness testimony or just argument by counsel?
I'm not saying there was witness testimony, but the way attorney's fees proceedings work is the attorney may speak to the actual fee presented or the actual fee incurred and the basis for it. There is abundant evidence. It's an extremely lengthy fee petition, including my affidavit, which we went over in detail. I would point you to the record pages, but again, they're not here because no transcript was filed.
I understand. Okay. Go ahead, counsel. Sorry.
Third, the circuit court did not err at all, much less abuse its discretion by awarding Genesis Diamonds a fee that represented just a small fraction of its actual attorney fees incurred during this multi-year and patently fraudulent litigation that the plaintiff extended at every opportunity. Turning to the first issue, Wilson County Circuit Court's unappealed final order in case number 2019-CV-512 renders moot as res judicata all claims presented in this appeal of case number 2019-CV-598.
All right, counsel, I'm sorry. Let me interrupt you again. Are you saying, and I guess I'm going to ask the question counsel suggested I ask or we ask, Are you saying there's two $10,000 judgments or only one $10,000 judgment?
No, Your Honor, there is only one, and there can only be one for a simple reason. Two separate cases, both of which were amended with a single amended complaint. Your question to opposing counsel was the right one. Did the amended complaint list both case numbers? It did. That amended complaint thereby destroyed the original complaints in both cases. So there is only one amended complaint, spans both case numbers, and the judgment applies across both cases. And Your Honors, even after being consolidated, the rule is that consolidated lawsuits remain separate actions. Thus, an appeal of an order in one consolidated case does not constitute an appeal of the separate but consolidated case. That holding comes from Rainbow Ridge Resort LLC versus Branch Banking and Trust Company, 525 Southwest 3rd, 252. The pin site on that is 259. I understand that the members of this panel are probably familiar with that case since two of them were on that case. As a result, Mr. Thomson's appeal of case number 2019 CV 598 does not constitute an appeal of the separate and consolidated case number 2019 CV 512. Your Honors, the time to appeal case number 512 has long since expired, so no court has any further jurisdiction to disturb it. And because Mr. Thomson did not appeal that case, it has never come within this court's appellate jurisdiction at all. Case number 512 also adjudicated on the merits the identical issues that Mr. Thomson raises in this appeal, and both cases involve the same parties. As a result, the circuit court's final unappealed and unappealable judgment in case 512 renders this appeal both res judicata and moot. I would also like to emphasize the fact that this has nothing to do with the informality of Mr. Thomson's notice of appeal. Mr. Thomson's notice of appeal is clear. It is specifically clear that he opted to appeal only one of the two consolidated cases. That's his problem here, and that's why unappealed case number 512, which is preclusive of this appeal, is not within this court's jurisdiction to consider. Prejudice does not factor into this at all. I could not consent to subject matter jurisdiction that this court does not have, even if I wanted to. Turning to the second issue, the reasonableness of the trial court's fee award is a factual determination that is conclusively presumed to be correct here. The rule that whether attorneys' fees are reasonable is a factual determination comes from Snyder versus First Tennessee Bank. That's Westlaw citation 2016 WL 423806 at page 8, 2016 case out of this court, where this court held, quote, "This court continues to review the trial court's factual determination of whether litigation costs, including attorney's fees, are reasonable under an abuse of discretion standard." In tandem with that holding, the rule is that in the absence of a transcript or statement of the evidence, this court conclusively presumes that the findings of fact made by the trial court are supported by the evidence and are correct. That comes from a host of cases that have been cited at length in Genesis Diamond's briefing, including In Re MLD, 182 Southwest 3rd, 890 at page 895. Your Honors, that is exactly the situation here. Mr. Thomson's entire appeal concerns the reasonableness of the trial court's fee award. But Mr. Thomson has strategically neglected to file a transcript or statement of the evidence of the hearing at which that determination was made. As a result, the circuit court's factual determination of reasonableness is conclusively presumed to be correct on appeal. Just to highlight this, Your Honors, it is also especially important to apply that rule faithfully in this particular case. The reason why is simple. Mr. Thomson filed a Rule 24 statement of the issues, which appears at page 369 of the record, and then premised this appeal on an issue that he did not identify. Specifically, none of the issues in Mr. Thomson's statement was a claim that the trial court abused its discretion in awarding $10,000 in attorney's fees under 2012-119C1 when it did not consider or apply any of the factors in Rule 1.5A of the Rules of Professional Conduct, which is the plaintiff's third issue and appeal on this appeal and what he premises the bulk of his claim on. That kind of bait and switch is prohibited. It affected Genesis Diamond's counter designation of the record and the rule that the trial court's factual determinations are conclusively presumed correct should be applied as a result. Third and finally, Your Honors, the trial court did not abuse its discretion by awarding Genesis Diamonds a fee that represented a small fraction of its actual attorney's fees incurred. Genesis Diamonds had a fixed fee representation that Mr. Thomson has not even alleged was unreasonable. Instead, Mr. Thomson argues that he is entitled to a more favorable fee arrangement than my client. Basically, Mr. Thomson insists that while my client paid a fixed fee, he should only be billed hourly as a sanction for maintaining his patently frivolous claims in this case. Your Honors, there is no authority that supports such a claim, and Mr. Thomson offers none. Fixed fee representations are expressly permitted by Rule of Professional Conduct 1.588. This court has upheld fixed fees as reasonable on several occasions, and as noted, Mr. Thomson has not even asserted that Genesis Diamonds' fixed fee arrangement was unreasonable.
Counsel, did counsel's affidavit set out what the fixed fee was?
Yes, I think I appended the check where it was paid. It was $30,000 fee.
Okay.
Instead, Mr. Thomson maintains that despite being the one who made every attempt to extend this litigation, he was entitled to a more favorable billing arrangement regarding the early dismissal of two of his claims, which no precedent supports at all. And no, Your Honor, the defense was not waived. They came, they made me argue it. I had to come for hearing. They opposed it at that hearing. There's no transcript there because, again, the appellant has not done its job of preparing this record and simply claims that things that are absent from it should support its claims. That's not the way this works. Your Honors, for these reasons and for the additional reasons set forth in our briefing, including, I want to emphasize, the harmlessness of the purported error under the circumstances of this case, the circuit court's judgment awarding Genesis Diamonds $10,000 in reasonable attorney's fees should be affirmed. Separately, Genesis Diamonds has raised a claim as cross-appellant regarding its entitlement to discretionary costs incurred in this litigation. I will rely on my briefing to support the claim. I think it's the parties' positions are adequately set out there. I think the trial court already taxed discretionary costs against Mr. Thomson. Mr. Thomson does not claim otherwise. Otherwise, the circuit court's judgment should be affirmed, and this appeal should be dismissed as res judicata. Your Honors, at this time, if the panel has any additional questions, I'm happy to answer them. I'd like to answer the questions that you asked opposing counsel just to clarify the situation here. Both cases are named on the amended complaint. Both cases are named on the order. Both cases were consolidated. Thereafter, Mr. Thomson only appealed one of them. That is dispositive. I feel badly that Mr. Schmidt was not familiar with the record of this case when he got involved in it. I feel badly for whatever happened between Mr. Thomson and previous counsel and Mr. Schmidt and not understanding the posture of this case. But ultimately, the unappealed case is not alterable. It was not appealed. It is not within this court's subject matter jurisdiction, and it is preclusive. Judge Frierson, you also asked about the transcript. You are correct. The transcript, the failure to file it, is dispositive here. You heard, and if you review the tape here, you will hear Mr. Schmidt mention the court's oral ruling. I would love to be able to point you to that oral ruling, but it's not in the record because Mr. Thomson has neglected to file a transcript of it. It is dispositive because the factual determination that is being challenged on appeal is not subject to any record review due to Mr. Thomson's failure to file a transcript or a statement. That's why trial court's attorney's fee award should be affirmed. But if you have any additional questions, I am perfectly happy to answer them.
I hear none, counsel. We'll hear from the appellate rebuttal.
Thank you, Your Honor. First, with regard to this transcript business, this was an argument. There was no witness testimony. There was no documents offered into evidence. The entire case was Genesis Diamonds counsel's affidavit. That's it. There was no, the transcript is not going to light the court as to anything. It's a complete red herring. Now, with regard to this res judicata thing, unlike Rainbow Ridge, Rainbow Ridge had two parallel litigations going on, one in Chancery Court, one in Circuit Court. This was one case. there's nothing in the court's reasons that I outlined in the statement of facts or in the order that indicated that this was a consolidation under Rule 42. This was a administrative snafu. If Genesis Diamonds Counsel concedes there's one judgment, there's only one judgment, then there can't be this lack of subject matter jurisdiction for failure to put a couple of numbers on the notice of the appeal. There's only one, if there's only one judgment, there's no res judicata here, and there's no lack of subject matter jurisdiction. Finally, with regard to this fixed fee deal, Your Honor, I think what counsel's arrangement was with his client is not dispositive on what the attorney fee Genesis Diamonds sought under the statute 2012-119, whether it was fixed fee or an hourly rate or even pro bono. It really doesn't matter, and it shouldn't be influential. Genesis Diamonds sought the fees under 2012-119 for the reasonable and necessary fees in dealing with these two claims that were dismissed. And it had the burden of proof there. And I'll submit it didn't sustain its burden of proof. And one final thing on this cost issue. You know, I've been a lawyer now longer than I want to admit. I've tried cases all over this state and other states, federal and state court. And whether a case a civil case is resolved by a jury's verdict or a summary judgment dismissal or a bench trial that results in a judgment or an appellate judgment or even a settlement, it's well known that costs in a judgment, unless otherwise specified, are filing fees. And that's it. I submit that this argument on the cost is without merit. I ask that be denied. I ask that the trial court's attorney fee award be reversed and remanded. Thank you, Your Honor.
Of course, thanks to counsel on both sides. We appreciate your briefs and your oral argument this morning.
Your Honor, if I may, with permission, just because I'm a cross appellant here, can I have 30 seconds to respond?
No, you should have asked before, so not now.
I understand.
That's fine. Mr. Hebner, will you please recess the court?
This court is now in recess. Yeah, this court is now in recess until 11 a.m.
Thank you. Thank you, lawyers.